Good afternoon. I'm David Lyle, the Deputy Director of the American Constitution Society. I'd like to welcome you to this conference toward a more perfect union, the Second Founding and the Reconstruction Amendments. I'd first like to extend greetings from ACS Executive Director Lisa Brown, who wanted to be with us today, but is instead detained in Washington serving as a senior member of President-elect Obama's transition team. ACS has a tradition of excellent programs and brief introductions. I will strive to hold up my end of that formula, confident that the other half will take care of itself. As Justice Thurgood Marshall noted, while the Union survived the Civil War, the Constitution did not. The amendments passed in the wake of that war profoundly altered the rights of individuals, the power of the federal government, and the meaning of citizenship. This conference brings together scholars from a range of disciplines and practitioners to examine the history and substance of the 13th, 14th, and 15th Amendments and how their promise can be fulfilled. It is said, probably apocryphally, that in China the saying, "May you live in interesting times," was intended not as a blessing, but a curse. But if we seize the moment, the interesting times in which we live may indeed prove a blessing. An opportunity exists to have, and for progressives to win, a great debate about the meaning of the words of the Reconstruction Amendments that define our nation. Those of us in this room should be, must be, leaders of this effort. Our discussions can shape the contours of that debate and provide a blueprint for the work yet to be done. At Gettysburg, Lincoln said that the world will little note nor long remember what we say here. And although Lincoln was completely wrong about his own remarks, I suppose modesty requires us to be at least a little humble regarding the importance of this gathering, even if what we say will be published in a law journal. But an appropriate humility should not cause us to underestimate the profound importance of the task before us. I hope you will participate in the roundtable discussions that will close the conference and open the next stage of our work. For all these reasons, the American Constitution Society is tremendously excited to be the lead sponsor of this conference. But many people have contributed to bringing us here today, and I'd now like to thank them. First, I would like to thank our two conference co-sponsors, the Constitutional Accountability Center and the University of Pennsylvania Journal of Constitutional Law, for working with us so closely and constructively. CAC is an organization dedicated to fulfilling the progressive promise of our Constitution's text and history, and thus is a natural partner for this conference. It is led by Doug Kendall, and ACS has no better friend. The Penn Journal on Constitutional Law is a forum for the interdisciplinary study of constitutional law and has graciously agreed to publish the papers from this event. ACS would also like to thank the members of the Planning Committee, each of whom shaped this event. Barry Friedman, who at the time of ACS's last major conference on constitutional interpretation 2 years ago, told us that we should sponsor a conference on the Second Founding and has kept the ideas coming ever since. Barry deserves special credit for somehow foreseeing in the fall of 2006 that a con law professor would win the presidency and choose a new birth of freedom as his inaugural theme. One does not encounter such prescience every day. Christina Rodriguez for her thoughtfulness and energy. Jack Balkin with his broad expertise, vision, and a grace on the dance floor unmatched in the legal academy. Doug Kendall with his practical perspective and his unwavering commitment to the progressive promise of text and history. Kim Roosevelt, who was generous with his time and talents and so kindly agreed to be our faculty sponsor here at Penn. Please join me in thanking each of them. I'd also like to thank the Penn ACS chapter for its contribution. This chapter has long been one of our best, and it has more than lived up to its reputation in assisting with this event. In particular, I'd like to thank Rachel Zurau, Miriam Nemeth, currently here at Penn, and recent graduate Donia Khalili, for all they did to make this happen, and for all of the students who are assisting here today and tomorrow. I'd also like to thank in advance Jeremy Adler, Kim Uhas, and the staff of the Penn Journal of Constitutional Law for the work they will be doing to publish the ideas we're going to hear about over the next day and a half. I'd also like to recognize a member of the ACS staff who has worked tirelessly on every detail of the conference, Shannon Hiller, our Programs Fellow. Many of you have had the pleasure of interacting with Shannon as we prepared for this conference, and you know how lucky we are to have her at ACS. As you can see, many have contributed greatly to make this event possible, but only one person has lived it, Mira Trahan, ACS's outstanding Associate Director of Programs. Her fingerprints, in the form of her thoughtful approach to difficult substantive issues and good-humored willingness to grapple with logistical tangles, will be on every single thing that happens over the next 2 days. Thank you, Mira. Finally, I'd like to thank each of the speakers for agreeing to participate and to all of you for attending. In the end, it's your participation that makes this event a success. I'd now like to turn it over to Doug Kendall of the Constitutional Accountability Center. Doug?
Thanks, David. Thanks, David, and thanks to all the folks, Mira, Shannon, and others at ACS for all their incredibly hard work in putting this together. We are so lucky that American Constitution Society is around and can pull off just remarkable events like these. I'm Doug Kendall. I'm founder and president of the Constitutional Accountability Center, a think tank, law firm, and action center dedicated to the progressive promise of the Constitution's text and history. We were set up in June of 2008 to try to shake up the debate over originalism in this country. Our argument is simple. Constitutional text and history is incredibly important. It's what judges should follow, and it dictates or pushes towards progressive, not conservative, outcomes across a broad range of topics. At the center of this fight is an argument about the amendments passed to the Constitution over the last 200 years. Conservatives tend to view the amendments as tinkering around the constitutional edges. We view the amendments as fundamentally changing the fabric of the document. At the center of this argument is the text and history of the 14th Amendment. That is why we are both proud and delighted to be co-sponsoring this conference with American Constitution Society and the Penn Journal. I think it is clear, it will be clear to anyone leaving this conference that on a number of hot-button legal topics, including the scope of federal authority to broadly enforce the mandates of Section 1 of the 14th Amendment, the extension of birthright citizenship to all folks born in the United States, including those of undocumented parents, and the protection of fundamental rights from encroachment by state actors. The text and history of the 14th Amendment is clear, and it dictates progressive outcomes. CAC's main contribution to the conference is a report that's available on the table out there that I hope all of you have picked up. It's called The Gem of the Constitution, the text and history of the privileges or immunities clause of the 14th Amendment. I'd like to recognize David Gans, CAC's Director of Civil and Human Rights, who is the lead author of the report, who's here in the audience today. I hope everyone can stick around for tomorrow for the panel on the Privileges or Immunities Clause. The emerging and new consensus left, right, and center by scholars about the critical constitutional role intended for the Privileges or Immunities Clause in protecting fundamental constitutional rights, and the movement by the Supreme Court towards a reevaluation of this clause is one of the most profoundly important and interesting developments in constitutional law in our generation. And it will be fascinating to watch how the Supreme Court navigates these waters in the coming years. This conference was originally scheduled in October of 2008. It was forced to move to November because of scheduling conflicts, and it's incredibly fortuitous that it did. Now we don't have to speculate about the world we will be living in 30 days. We now know that in January we will be swearing in the nation's first African-American president, who who has an inaugural theme of the new birth of freedom. The ideas discussed at this conference are deeply relevant to that theme. The Reconstruction amendments were designed to give the nation the new birth of freedom Lincoln promised us at Gettysburg. Fully honoring these new birth of freedom amendments is the nation's unfinished business, and I think we should all be considering, as we listen to the panels and speakers over the next 2 days, how we can move these ideas from this conference room, from this conference, into the mainstream of political dialogue, both about the inauguration and in the new administration. We've tried to start some of this conversation on Constitutional Accountability Center's blog, which is at textandhistory.org. But we hope over the course of the next couple days and in the ensuing months, we can all talk together and join and strategize about how to make the ideas that are going to be discussed and are so inspiring at this conference come to life. Thanks very much.
Good afternoon. I'm Kim Roosevelt. I'm a professor of law here at Penn Law School. I'm also the faculty advisor of the Penn chapter of the American Constitution Society. And on behalf of the law school, I'd like to welcome you all here today. I'll be very brief. Given our location, the University of Pennsylvania has a special interest in our nation's constitutional history. Philadelphia, of course, is the birthplace of the Constitution, and it's justly celebrated for that. And the founding is justly celebrated as a great moment in American history more broadly. But American history certainly didn't end with the founding, and American constitutional history didn't either. And that's what this conference is about: the second founding, the Reconstruction amendments, the new birth of freedom. Over the next days, some of the nation's leading experts will take a closer look at our constitutional history and the changes to our Constitution that built upon and corrected the document drafted here in Philadelphia. Penn Law is excited to be hosting this conference, first, of course, because of its wonderful content. But the format of this conference is also very much in keeping with Penn Law School's approach to legal education. At Penn, we value a cross-disciplinary approach to legal thinking, and this conference, by bringing together historians, political scientists, practitioners, and legal scholars, promotes just that. Finally, I'd like to thank the sponsors of this event: the American Constitution Society, the Constitutional Accountability Center, and the Penn Journal on Constitutional Law for their work on this important event, and also to thank all of you for coming. We're looking forward to a great time. Thanks. Yes, if you want to. Well, hi, it's me again. Welcome to our first panel. We're going to talk about originalism and the second founding generally, in order to set the stage for some more specific panels later in the conference. And we're going to be asking why the originalist venture tends to focus on the Philadelphia founding rather than Reconstruction, what challenges the second founding poses for originalism, and what originalism might look like if it took those challenges seriously, which is a broader question about historicism in constitutional law. And I'm Kim Roosevelt. I'm the moderator. I'm delighted to have such a wonderful panel here, and I will introduce them to you in the order in which they're going to speak. I should say first, we were hoping to have Roger Wilkins here, but he was unable to attend. However, I look forward to a wonderful panel, even in his absence. So, proceeding down the row here, first, Barry Friedman. Barry Friedman is the Vice Dean and Jacob D. Fuchsberg Professor of Law at New York University Law School. He's one of the country's leading authorities on federal courts and a noted scholar mining the intersection of law, politics, and history. He writes about judicial review, constitutional law and theory, and has a book forthcoming from Farrar, Straus, and Giroux called The Will of the People, the Supreme Court and Constitutional Meaning, which explores the history of the relationship between the Supreme Court and popular opinion from the founding to the present. Michael McConnell is a judge on the 10th Circuit Court of Appeals and the presidential professor of law at the University of Utah S.J. Quinney College of Law. Prior to joining the faculty at Utah, he taught at Chicago and served as an assistant to the Solicitor General. He's published widely on constitutional issues, including originalism and the religion clauses, and he's also argued 11 cases before the Supreme Court. Jack Balkin is the Knight Professor of Constitutional Law and the First Amendment at Yale Law School. He's also the founder and director of the Information Society Project at Yale and the mastermind behind the popular legal blog Balkanization. He's written on a dizzying range of subjects, from the interpretation of the I Ching to memetics. Two of his recent books are What Brown v. Board of Education Should Have Said and What Roe v. Wade Should Have Said. Reva Siegel is the Deputy Dean and Nicholas de Belleville-Katzenbach Professor of Law at Yale Law School and a Professor of American Studies at Yale University. Her scholarship uses history to explore questions of law and inequality and to analyze how courts interact with representative government and popular movements in interpreting the Constitution. She's the co-author, with Jack Balkin and others, of one of the leading constitutional law casebooks and is the faculty advisor for the Yale chapter of the American Constitution Society. Each of our panelists will speak briefly. We're hoping to have a good conversation with all of you in the audience. So we'll have just brief remarks by each panelist, and then my plan is to open it up to discussion more generally, general discussion, including, of course, any comments that the panelists might have on each other's presentations. So you can speak from your seat. You've got a microphone if you would like, or if you would like, you can also move up to the podium.
Hi, so I'm Barry Friedman, and there have been lots of thank yous, but I want to also thank Penn for having us and the organizations that are sponsoring this, and I especially want to thank Mira Trehan, who did a terrific job putting it all together. It's true, and I'll accept the shout out, which is that I sat at the Vanderbilt conference talking about constitutional interpretation, and I thought how odd it is that when we talk about originalism, the originalism that we talk about is always the founding moment in 1787, whatever happened to the thing after the Civil War, where we added what are certainly some of our more foundational amendments to the Constitution. And so we began to call it the second founding, and that's what we want to talk about. And I'll point out it's not just originalists who seem obsessed with the original founding. It's true in popular culture. If you wander into the bookstore, and I was just looking, there's lots of books and ever-growing on what happened in 1787 and a remarkable disparity with regard to the period of Reconstruction. I think the Supreme Court, for reasons I'll touch on in just a moment, is much more game to touch the founding moment than it is the second founding. They're a little afraid of it. And so we thought we'd have this conference to talk about what we ought to make of the second founding. And I'm looking as forward as everybody is to sitting in the audience and listening to people who are really experts on this subject matter talk about that period, because I'm not one. But this panel is devoted to methodology, to what we ought to think about how the moment of Reconstruction should affect constitutional interpretation more generally. And I want to talk about that, and my paper title pretty much says it all. It's called Reconstructing Reconstruction, Some Problems for Originalists and Everyone Else Too. So I want to point to 5 aspects of the second founding moment that I think complicates interpreting the Constitution, again, not just for originalists, but for anybody who wants to interpret the Constitution, but especially originalists. And I just want to make a point, which I'll come back to, which is I think that the reason this is that we like to tell what I'll call straight-line stories. We like to try to interpret the Constitution in a way that draws a straight line between what happened at a founding moment and where we are now. But as you'll see from Reconstruction, the path was anything but straight, and so we're not sure how to take account of that. So the 5 problems, just to tell you up front, are interpretation, integration, rejection, revision, and rebirth. So the first interpretation is, look, it's always hard to interpret a Constitution with regard to its founding moment and apply it to something down the road, but it's particularly difficult to do with regard to Reconstruction because it was such a difficult and at some level inaccessible foundational moment. So I'll begin this by just reminding you that when originalism was on the ascent in the 1970s and 1980s, there was an important move that happened from original intentions to focusing on what the people who wrote the document thought the answers to questions ought to be, to the original understanding, to what the ratifiers and people who were living at the time would have understood the document to mean. And I actually have an argument, which I don't have time to tell you now, about why that switch was wrong. I mean, everybody in the world seems to have bought into the idea that we should talk about understandings and not intentions, and I think it's probably wrong. But even if we buy into it, the problem is that the materials necessary to do that kind of original understanding work are very difficult to access with regard to Reconstruction. So Larry Kramer had an interesting point. He said, you know, at the very moment when originalists were looking at the switch from original intent to original understanding happened to coincide with the publication of the documentary history of the ratification of the Constitution. So it was handy. We all had like big sources of materials we could go to and figure out what ratification meant. But with regard to the 14th Amendment or with regard to much of Reconstruction, those materials just don't exist. I mean, in some cases, they literally don't exist. Most states don't have records of the ratification debates. And so it's going to be very hard to get a hold of that. We're either driven to sort of trying to make sense of all the external sources, which is a very, very difficult thing to do, newspaper articles and debates and arguments that people had, or to go back and focus once again on Congress, which looks much more like an intentional rather than a sort of understanding moment. And as you'll see from the conversations that we have along the way over the next couple of days, fathoming what happened in those debates in Congress is extremely difficult. The second problem is one of integration, which is that if you want to interpret a Constitution, you have to interpret all of the Constitution, and you have to do it across time. You have to do it as new clauses are added into the Constitution and layered over it, because those later clauses are going to change the meaning of the earlier original founding moments. And you sort of have to refract backwards like that, which is something we don't often do. So as an example I'll give you, take the 11th Amendment and the 14th Amendment. So the 11th Amendment basically says the states can't be sued in federal court. And the 14th Amendment says states have certain obligations and Congress can enforce those upon the states. So what if Congress decides to invoke its enforcement power under the 14th Amendment and say states are liable for suits in federal court? Well, one thing you could say, perfectly plausibly perhaps, is that's not legitimate, that Congress can't hold the states liable in that way, that whatever the 14th Amendment did, it couldn't change what came before. But that's not at all what the court has said. So in Fitzpatrick versus Bitzer, when it was confronted with the question, what the court said was, actually, the 14th Amendment came later in time than the 11th Amendment, and it changed some of the basic understandings of the 11th Amendment and of federalism, and so Congress does have this power. We have to understand the 11th in light of the 14th. And I just want to read you a couple snippets of Reconstruction history so you can start to get the flavor of why we might have thought that, because our understandings of federalism changed dramatically in that period. So this is Richard Gates, who was a radical Republican from Illinois. He says, "I had in the simplicity of my heart supposed that states' rights being the issue of the war had been decided." Or one of his colleagues who said, "Hitherto we have taken the Constitution in the solution of the spirit of states' rights. Let us now take it as it is sublimed and crystallized in the flames of the most gigantic war in history." So the whole underlying understanding of the Constitution changes, and we read the Constitution backwards that way. That'd be great, except that we're not consistent in that at all. I have lots of examples I don't have time to discuss, but the one I want to point to is, of course, the Supreme Court's more recent 11th Amendment, 14th Amendment cases like Seminole and Garrett, where the court adopted a much more stinted view of federalism and therefore limited Congress's power to impose remedies on the states in federal court. Now, the reason for that is the third thing that happens to constitutions, and also a difficulty for originalists, I think, which is sometimes we reject them. Sometimes, even though we've gone to this entire trouble of adopting constitutional text, we then change our minds about that constitutional text, or it falls into desuetude. And so there's this remarkable moment in United States versus Morrison, the Supreme Court's decision in which it strikes down the civil damages remedy in the Violence Against Women Act, where it says, well, we have to do this because shortly after the adoption of the 14th Amendment, in the civil rights cases, we said that there's only a remedy against state actors and not private individuals. And it's that shortly thereafter thing that's incredibly amazing. It's sort of like the court saying, well, the civil rights cases came not long after Reconstruction, so those guys knew what Reconstruction was really about, and so we should take their view for what it was really about. But, you know, the civil rights cases came 15 years after the ratification of the 14th Amendment, and everything changed in the country in that period. The country basically turned its back, as many of you know, on Reconstruction. The economy had transformed. We had moved from a sort of localized economy to a national market economy. The economy had then crashed in 1873. The country sort of lost its will to enforce Reconstruction on the states. And so we get this kind of a comment. So this is the Springfield Republican. We have tried constant partisan intermeddling from Washington and bayonets ad lib. The malady does not yield to the treatment. Let us now try a little vigorous letting alone. That's what the country wanted to do with Reconstruction, and the court bought into it hook, line, and sinker, and in a series of cases basically took Reconstruction apart. And as the court took Reconstruction apart, the country applauded. So here's the New York Times. This is right after the court strikes down the Civil Rights Act of 1875 and the civil rights cases. The New York Times says, "The judgment of the court is but a final chapter in a history full of wretched blunders made possible by the sincerest and noblest sentiment of humanity." So quite a switch from what people were thinking at the time of Reconstruction. And what had changed in part was our view of how the federal system should work and the extent to which the national government should be imposing its will on the states. So New York's Independent, which had been an abolitionist newspaper, said in response to the Cruikshank case, "To assume state powers as the method of punishing wrong in the states would be an experiment with our political system that had better be omitted. Southern questions must be left to the states themselves." So we just flat out rejected what had happened in Reconstruction, and we need to take account of that. The fourth thing that happens, which I don't have much time to say about, but I want to say a little bit, is revision, which is sometimes after we adopt constitutional amendments, we then change our mind about what they mean altogether. So a lot of the sort of property rights that originalists in particular tend to value and like to trace back to the original founding come from the period after the collapse of Reconstruction, the Gilded Age, where the Supreme Court then takes the 14th Amendment and reshapes it into a tool for protecting business and for protecting interstate commerce, the sort of decisions that lead us into the Lochner era. And so that period, again, is a complete rewriting of the 14th Amendment that we usually don't take account of. And finally, the last thing that happens to constitutions is they're reborn. So take Brown versus Board of Education. Certainly there's a desire, particularly on the part of originalists, to take Brown and connect it to the original Reconstruction moment. So Judge McConnell, who's on my left, is a good example of somebody who's worried over that problem. And you can try to do that, but there's a problem with it, which is that if you just try to take Brown and you say, well, okay, finally now we can forget all that bad stuff that happened in the middle. We're just going back to the original 14th Amendment. What you do is you do a disservice to everything that happened in between. So for one thing, it denies the entire disenfranchisement of African Americans and the apartheid that follows in the South and how that might have influenced American politics dramatically in the period between Reconstruction and the moment that we're living in now. For another reason, you can't really be true to the 14th Amendment after you've abandoned it and then you're sort of bringing it back. So one of the puzzles that originalists have never dealt with satisfactorily, at least I've not found it in the literature, is what about women and gender equality? So that we all sort of accept as an interpretation of the 14th Amendment now, but there's no way to really understand that except as the response to the intervening social movements that happened between the time of Reconstruction and the gender equality cases that brought us to the present. So 5 problems that I think make it difficult to interpret the Constitution as just a sort of, here's Reconstruction, it was a founding moment, we can just move directly from that to where we are at the present. And the only last thing I want to say, I don't know how I'm on time, but probably tight.
Oh, you're fine.
Okay. So I've been rushing, but I'll pause. So I think the only choice that we have is to synthesize, to sort of take the history that we have and understand how it layers atop of itself and make sense of that history that we've all lived through as a way of interpreting the Constitution, rather than trying to move directly from a foundational moment to where we are today. The only thing I'll say, though, and it struck me as I was writing this, is, judges are in a funny position because judges have no choice at some level but to draw a straight line. I mean, that's what they do. That's sort of the common law tradition. They have to, it's a backwards line. They sit where we are today and we say, how can we trace our way back to where we were? How can we understand that we came from this period before and now we're here and we're going to tell a story? We're going to tell a story from where we were to where we are now and how, but what we sort of omit in that is the how we got there. And I think the how we got there is really, really important, that we can't neglect that. And we have an obligation in interpreting the Reconstruction Amendments to understand the entire path that took us to where we are today. The adoption, the way that it influenced the original Constitution, the rejection of the 14th Amendment and what that meant, the revision that we lived through, and then its sort of counter-revision in the New Deal period to the rebirth that we've lived through and now a new rebirth of freedom.
Well, it's nice to be at a conference that isn't just going over what we've all been talking about before. This is a new event, I think. I can't remember another conference, at least in the 20-some-odd years I've been interested in the general question of history and constitutional interpretation that focuses upon the problems of originalism and the second founding. I think that's great. Another thing I think is interesting and perhaps new, and I detect this not just in the, looking at the whole program of this conference, but listening to Doug Kendall and his introductory remarks that maybe this marks a time in which a number of people are perhaps going to look at the whole question of constitutional interpretation, including originalism, with in a new way, and perhaps entertain the prospects that originalism may be, after having excoriated it and complained about it and denounced it for so long. Well, maybe there's something. Maybe it's now going to have a more favorable reception, and I think he's entirely, I'm again referring to Doug Kendall, entirely right that, at least from my studies in the period, that those on the left of the spectrum are going to find some aspects of this history which are powerfully supportive of some of their constitutional ideas. It will be a mixed bag, let me tell you that, but it's certainly, I think, worth doing. I do want to just say what I think originalism means, because I think it's one of those words that has lots of different possibilities and is frequently caricatured. I don't swear that everybody who calls himself or herself an originalist takes this view, but just for one understanding, because I think some people imagine that originalism means that for every constitutional question we ask, well, what does the Constitution as originally understood say about that, sort of full stop. The plain fact of the matter is that the Constitution doesn't speak to every constitutional question, and so that it's the full stop that's the problem. The way I see originalism working in conjunction with other legitimate forms of constitutional interpretation is this, that the text is the beginning, and the text by itself, even without looking at anything else, does mean something. That is, it excludes there's some things that are simply not tenable interpretations of our Constitution. There's some things that are pretty clear. So there's some things that are settled and no one worries about. There's some that are just off the page. But there then is quite a range of interpretation of the number of important problems where the text creates the range or defines the range but doesn't tell us one particular answer. The next step is to look to the original history, the original meaning, which will further elucidate what those words mean and will narrow the range of possible legitimate interpretation, thus excluding some things and making others pretty clear. Even after that, though, there's still going to be and are many important areas where there's still legitimate interpretations within the range of the words understood as best we can according to their original meaning. And the next thing that we do is we look to past practice, not just to Supreme Court precedent and other court precedent, although that's part of it, but at least by my lights, especially to the interpretations and practices of democratically accountable institutions over the 200 some odd years since the ratification of the original, or the 150 some odd years since the ratification of the second founding, and that I think we find that, again, those past practices narrow the range of what we would consider to be legitimate interpretations. Some things are simply off the table because the American people and our court system in some combination have decisively gone one way or the other on those questions. Now, at the end of that, there still are problems where there's a legitimate range of interpretation. And for me, this may be a point in which I differ from many in the room. At that point, I think the task of legitimate constitutional interpretation has come to an end, and what the courts should say, if they are the interpreters, is at that point it's within a legitimate range and the democratic will of the people expressed through democratic institutions win. That's the end. I don't believe that we should ask the further sort of Dworkinian question about what is the best philosophical answer to the question. I think if the democratic branches have decided and it's within a legitimate range of interpretation, beginning with text and through original meaning, past practice, and so forth, that's the end of the matter. But that's the judicial restraint part of the interpretive project. The originalism part, which is what this conference is about, does have to do with encountering, trying to understand original meaning as best we can, and here we're particularly speaking of the second founding. So I want to pick up on some of Barry Friedman's thoughts here about why is it that there hasn't been much done on this by scholars of the left or the right, by the court. There certainly are cases where you would just expect to see historical discussion brought forth, and it's so frequently not there. Why might that be the case? Barry alluded to the problem of sources, which is in fact a very serious technical problem. Some of the most important decisions were made by the Joint Committee that did not keep notes. We know so little about why they decided things, and in any event, the sources are a problem. But there are a couple of other problems that I think are important and that a group like this needs to face. First problem, I think, and maybe it's time to get over it, is the problem of Brown versus Board of Education. Because for about as long as I can remember in these debates, those whom I'm going to non-pejoratively say are on the left of the political spectrum have used Brown versus Board of Education not so much as a serious question in constitutional interpretation, but as a club with which to beat the baby seal of originalism. And as long as Brown versus Board of Education can be said to be inconsistent with the original meaning, that means that original meaning is simply discredited and we don't have to talk about it anymore. That has been a trope in constitutional discussion for a very long time. Now, I think it's false. I'm not going to go through all of the evidence. One place you can see my thinking about this is in Jack's, a chapter in Jack's book on what Brown versus Board of Education should have said, but I'm quite convinced, and I've read all of the counter-arguments by our friend Mike Klarman and others, and remain convinced that the fact that that repeatedly both houses of Congress, with votes almost getting even to 2/3 on a number of occasions in the early 1870s, vote for legislation enforcing the 14th Amendment, legislation that would have abolished segregation in public schools. I think that is an important fact that legitimates Brown under originalist thinking. So I think the club can be put aside and that we should all try to enter into the project that Doug Kendall and other originalists put forward, which is now to think about what the actual original meaning is. Second problem, which has more to do with precedent than it does with Brown or with sort of ideological infighting. It so happens that the Supreme Court's first major interpretation of the 14th Amendment was flatly incorrect, this being the slaughterhouse cases. Right? And as a result of the slaughterhouse cases being decided, 14th Amendment jurisprudence ever since has been distorted. Not just the jurisprudence of the Privileges and Immunities Clause, which was reduced from being the centerpiece of the 14th Amendment to meaning virtually nothing, but then when the Supreme Court got more inclined to read some meaning into the 14th Amendment, rather than going back and saying, oops, we made a mistake, they then pump meaning into the other clauses of the 14th Amendment that in some cases isn't there. And so we have this distorted jurisprudence of equal protection and due process, which I think would never have happened if the slaughterhouse cases had not gone this way. But that creates a problem for those of us who might be inclined to move in an originalist direction with respect to the Reconstruction amendments, because there's just so much erroneous Supreme Court jurisprudence standing in the way of doing that. Unlike the original founding, where of course there are lots of wrong decisions by the Supreme Court, but they're kind of miscellaneously wrong and therefore can be, they can be addressed sort of problem by problem. It's not sort of root and branch from the beginning, wrong turn wrong, in the way that Slaughterhouse led us to go. So I think those are a couple of reasons why originalism has not been a very popular mode of thinking about the 14th Amendment. Once it becomes a more popular mode, there are going to be there's some oddities, and this is again picking up on a little bit in what Barry has just said, but there's some things about the 14th Amendment history which we don't encounter elsewhere. One of them is the brute fact that in order to get to the requisite number of states for ratification of the 14th Amendment, the Congress coerced the states into ratifying. That is, southern states were not permitted to rejoin the Union unless they ratified. They were, and that means that whether you're talking about original intent jurisprudence or original understanding jurisprudence, the general idea that we focus on what the ratifiers understood or intended makes no sense for the 14th Amendment. What the good people of Alabama intended and understood was that this is the only way they were going to get back in the Union. They didn't care. It could have said, we're abolishing Christmas, and they would have ratified in order to get back in. So that's a problem for trying to conceptualize whose intent, whose understanding. There's another problem, too, which is that in many cases, some of the most obvious results of the 14th and 15th Amendments seem to fly in the face of widespread public opposition as of the time. And so, Michael Klarman frequently makes an argument of the following form. It couldn't have meant that. It couldn't have meant desegregation of the schools or whatever we happen to be arguing about, because almost everybody was, or huge majorities, even in Republican states, were against that. And that's and ordinarily, the fact that a lot of people are against something is pretty good evidence that they must not have meant that when they supported the particular amendment at hand. Well, so how did this happen? Well, part of it is the fact that those who controlled readmission of the states were able to use their position in Congress to force it through. But part of it also is that there was this weird, not very candid character to the debates going on, in which, if I can be this is not accurate, this is just a stylized version of what happened, but roughly a third of the population were opposed to any version of the 14th Amendment, and they said that they believed it meant very extreme things, right? Then about a third of the population, maybe even less than that, actually favored some pretty extreme things and were for it because they thought they were. And then there was a significant group, call it a third, somewhere in the middle, that said, oh, no, it really doesn't have such far-reaching implications, and that's why we can support it. Well, if you put those three groups together, and again, this is highly stylized, you have roughly two-thirds of the country saying that the meaning of the amendment is quite extreme, right? And you have roughly two-thirds of the population saying, we're for the amendment, right? But it isn't. The composition of those groups are different, and so it makes for a very strange interpretation of what do we do with these various statements that people make at the time about its meaning. And there is no such parallel in the original founding, where of course there were differences, but the differences were there was the most diehard anti-federalists were not root and branch against the enterprise, right? So it just didn't happen this way. And then one final point, and I will subside, is that partly because of this, partly because of the lack of the sources, partly because of how thin the discussion was of the content of Section 1, partly because Section 5 was so important, congressional power to enforce was so important, we need to look for 14th Amendment interpretation much more to post-ratification evidence than we do back at the original founding. We do, of course, look to post-ratification evidence for the original founding, but it isn't central to the interpretive enterprise. But I submit that the most important evidence for what the 14th Amendment meant can be seen in the debates and enactments of the Congresses in the immediate years after the 14th Amendment in the series of statutes that they passed to enforce it. Thank you.
Hi, everyone. I was going to talk a little bit about originalism, but before we talk about it, you should understand that there are so many different varieties of originalism that to talk about the relationship between originalism and the Reconstruction Amendments, you first have to ask the question, well, which one? And I don't have enough time to go through all of them, but there's the old originalism, and then there's the new originalism, and I would guess I would be...
And the middle-aged originalism. The middle-aged
originalism. And I guess I would call myself the new originalism, right? So let me say a little bit about the new originalism, and maybe we can go from there. One way of distinguishing this emerging form of originalism is the idea that the focus of previous forms of originalism was on restraining judges from doing bad things. Newer forms of originalism are less interested in the question of judicial restraint and more interested in the question of constitutional fidelity. That is, getting the right answer to what the Constitution compels us to do. It follows from that we're interested both in how the Constitution gets built out, both by the judiciary and by the political branches and their interaction. My particular version of it is interested in a distinction between original meaning, which is binding on subsequent interpreters, and original expected application, which is not. The expected application is how did the people who wrote the language think or imagine that it would likely be applied to circumstances. That's not binding originalism. However, the original meaning, that is what concepts are being used, that is. And that gives you a very different take on what originalism is, because often the ideas of original meaning and original expected application tend to be mushed together in practice. And this form of originalism tries to separate them as much as possible. I mentioned that because this conception of originalism I'm offering here is tied to a larger question, which is a question of constitutional design. And let me say a few words about constitutional design. If you think about, so let me just give you two stylized versions of an originalism, one which I'll call framework originalism, and one which I'll call skyscraper originalism. And by the way, these are ideal accounts. Nobody really is a skyscraper originalist, but I'm using it as a foil. The skyscraper originalism idea is that the Constitution, when it is created through Article 5 or through adoption, is more or less finished. It's more or less a finished thing. It's always subject to later amendment, but basically that what it prohibits and what it doesn't prohibit is pretty much determined when you finish it, by whatever methods of interpretation you think are appropriate. Everybody else who comes later can obviously work within it, in the building, right, but the building's finished. And what they do isn't constitutional construction. They're not building out the Constitution. They're not adding anything to the Constitution. What they're doing, rather, is they're engaged in ordinary politics. They're just passing ordinary legislation and doing what they ordinarily do. Framework originalism is a very different conception. Framework originalism assumes that when you build a Constitution, what you're really doing is building a framework which is incomplete. And you're making politics possible. That's the purpose of a Constitution, is to make a stable politics that can occur over time possible. But you don't settle everything at once. You put the framework in place, and then people who come after you, they have to construct the Constitution. They have to engage in what's called constitutional construction and build it out. And the people who build it out are the legislative branch, the executive branch, the federal government, the states, and the judiciary. All of them are engaged in the process of building out the Constitution over time. To give you an example, You could understand, for example, the Voting Rights Act, or the Civil Rights Act of '64, or the creation of the Federal Reserve Bank, or the creation of the Department of Justice, and the Attorney General and Solicitor General as ways of building out constitutional values and constitutional obligations over time. That's the work of constitutional construction. You can also understand the creation of doctrine by courts implementing constitutional meaning in practice in ways that are often controversial, and precisely the way Michael suggests, as being constitutional construction. Framework constitutionalism assumes that when you build a constitution, it's never complete, it has to be built out, and most of the work is done by the political branches and by the courts working together over time. Well, I want you to see that this is related to the idea of how you design a constitution and why it's designed the way it is. So take the 14th Amendment as an example. In fact, you can think of the 14th Amendment as being a kind of microcosm. It has in it everything you have in a constitution. So, for example, if you look at the language of the 14th Amendment, look at Section 1 and 5 and compare it to Sections 2, 3, and 4. Sections 2, 3, and 4 have lots of rules in them. Section 2 makes a compromise about voting. And it basically says that if you deny the vote to adult males, then your representation will be diminished to that degree. That's a compromise over black suffrage, because they couldn't, in fact, reach a compromise, so that's what they did. That's what they did. So it's a rule. Section 3 basically is the de-Ba'athification provision, right? Basically is, what do you do with all of these former Confederates? And the answer is, you allow them to re-enter government if you go through a process by which they're approved by the national political process. There's a lot of debate over this, by the way, in the debates. Much more over this, in fact, than over Section 1. And then the fourth section basically says, we're not going to pay the Confederate debt. We are, however, going to pay the Union debt, and nobody gets a claim for lost slaves. That's number 4. If you look at 1 and 5, 1 and 5, except for the citizenship clause added at the very end, which states a rule, a jus solis, right, a rule of when you become a citizen. 1 is full of glittering generalities. It talks in abstract terms, privileges or immunities of citizens, due process of law, equal protection of the laws. Very, very different type of language than the language used in 2, 3, and 4. And 5 is a general clause giving Congress the power to enforce through appropriate legislation. This is a callback to McCulloch, right? Very broad grant of power to Congress to enforce what's in 1, 2, 3, and 4. But since 1 is full of these glittering generalities, it's actually a considerable delegation to figure out what 1 means. And that's not an accident. Congress assumed that after Dred Scott, the courts would not be the friends of rights. Rather, Congress would be the great friends of rights, and Congress would build out and determine what the rights were. What can we learn about constitutional construction by just looking at the 14th Amendment? Well, we learn a couple of things. When people build out constitutions, they leave a lot of things silent because they can't agree. They make compromises because they can't otherwise agree. And they put some hard-edged rules in there because they want to constrain what people do later on. They want to settle things to make it possible for politics to go on, but they also include language that includes vague and general and abstract concepts. And every constitution that I know of, especially after World War II, contains both of these things. They have rules, hard-edged rules, they have standards, they have principles, and they have silences. And the rights provisions in most post-World War II constitutions and also the American Constitution usually are glittering generalities. Freedom of speech shall be guaranteed. The rights of man shall be guaranteed. Everyone will be treated equally under our Constitution. And you might think, was this because people who write constitutions are stupid? Is it because, you can drive a truck through that stuff? No. The reason is they understand what constitutions do. Constitutions structure politics. Certain things you have to nail down with a hard-edged rule. Certain things you can't. You have to leave them open through abstract guarantees, and what you're doing is channeling politics. You're making politics possible in a certain way by articulating a language of rights and guarantees, which will have to be fought over by later generations, and which later generations will have to build out over time. And that, in fact, is not stupid at all. It makes perfect sense if you think about people designing a constitution that's going to last for a long time. And that's the Constitution we have, by the way, in the United States. And you can learn a lot about constitutional interpretation by thinking about constitutional language from a designer's perspective. And think about, well, we're going to set this in motion, and it has to be built out by a bunch of other people. And that's basically the lesson I want to leave you with. that, in fact, if you think about why people would write certain language in a Constitution, why they would use rules, why they would use standards, why they would use abstract principles, glittering generalities, and silences, you can see that what they're doing in large part is delegating the task of fleshing out and implementing the Constitution, that is, engaging in constitutional construction, to future generations. In this way, they are constructing, we might say, an intergenerational project, a project that begins with creation of the Constitution's text and which bequeaths to each generation a responsibility to make its promises real in its own time. That is what the 14th Amendment does. That's what we mean, in a sense, by a new birth of freedom, and that's how you should interpret it. After all, when a baby is born, the baby isn't an adult. The baby doesn't know what it's going to be yet. It becomes an adult over time, and this is also true of constitutions, and it also has to do with the way in which we interpret them. That's why, by the way, we should make a strong distinction between the original meaning of the text, that is, what is the abstract concept the Constitution requires us to enforce, and how it was expected to be applied at the time. That expectation looks only to the moment of adoption and to a small amount of time in the future. In fact, the use, though, of the abstract clause says each generation is going to have to ask itself, how do we apply this guarantee in our time? How is it going to shape our politics in our time? How are we going to make the Constitution live in our time? Which leads to my conclusion, that if you think about originalism from a designer's perspective, it's living constitutionalism.
Okay. First of all, I would like to again thank the organizers of this conference. I think the question is really a lively and a provocative one. And in fact, in my remarks today, I'm going to be taking some concepts familiar to me and attaching them to some history that's not so familiar to me. And it gives me pause to even discuss it, because as I look out into this wonderful assembled group, I can see many people who are far more studied and literate in the domains about which I'm speaking, but that's what's fun about this question. It cracks things open from a new angle. I have recently been puzzling about originalism, but it's been actually on the Second Amendment in the Heller case and the Founders' Constitution, as it were, and not Reconstruction. So here we go. I understand, perhaps not surprisingly, the Reconstruction Amendments to be the fruit of a social movement, a movement that was passionately critical of the Founders' Constitution. The abolitionist movement was a great constitutional innovator, and one of its most important innovations was to demonstrate new and newly democratic ways of expressing fidelity to the Constitution. Abolitionists showed Americans that it was possible to criticize commonplace understandings of the Constitution, to break with the Constitution as understood by its framers, as enforced by the political branches, and as interpreted by the courts, and still express fidelity to the Constitution. Through these shifts in constitutional culture, abolitionists helped grow the understandings that would ultimately be expressed in the text of the Reconstruction Amendments. And so in my remarks today, I want to think a little bit about the shifts in constitutional culture that gave rise to the Reconstruction Amendments, and to note some deep tensions between these forms of constitutional culture and at least some prominent forms of or understandings of originalism. First, I want to start with my usage of constitutional culture. The concept that as I'm using it today is something that I elaborated in a piece by that name on the de facto ERA. What's important for these purposes is simply the following, that in talking about constitutional culture, I'm not talking about sort of general social values, for example, understandings of race or understandings of family role, or for that matter, knowledge of the Great Depression that interpreters of a constitution might bring to the ways in which they construe its text. Rather, I want to focus on a more specific understanding, that is to say, about the understandings of the culture that's specific to the culture of the constitutional order, understandings of or concerning the Constitution, in particular the understandings of role and practices of argument that guide interactions among citizens and officials in debates about the Constitution's meaning. Okay, so you see the slight shift in focus that I'm inviting here. On this view, constitutional culture is providing citizens the confidence and the tools to assert new readings of the Constitution, and even when these alternative or insurgent understandings of the Constitution are at odds with official accounts of the Constitution. Constitutional culture is also providing officials who are charged with enforcing the Constitution, the kinds of role authority that allow them to resist or alternately to attend to these new understandings of the Constitution's meaning. So in short, constitutional culture is that which defines the boundary between law and politics. It's going to channel constitutional change and regulate beliefs about when constitutional change requires lawmaking, an amendment, for example, or when it can proceed by interpretation. So the abolitionists are deeply divided in their understanding of the Founders' Constitution. And I want to focus a little bit on the dispute within the movement, and this is where I will defer with delight to the many experts in the audience here. I want to focus on the difference between Garrisonians who advocated disunion and saw the Constitution as basically evil and a pro-slavery pact, the familiar covenant with the devil language. Their view of the Constitution was fairly positivistic. They understood, had a sharp distinction between law and morality. They made sense of the Constitution by paying attention to its official interpretation. The revelation of the Madison Papers, the account of the Constitutional Convention, which comes out in the 1840s, is significant in fixing the meaning of the Constitution. So too are the understandings of ordinary governmental actors. These help define what the Constitution means and help make it a pro-slavery document. Wendell Phillips, taking this view of the Constitution, whose meaning is fixed and morally objectionable in the deepest degree, says the only path to justice is, quote, over the Constitution, trampling it underfoot, not under it, trying to evade its fair meaning. I want to contrast these abolitionists with, I'm now looking at Randy, Lysander Spooner and Frederick Douglass and others who essentially avoided this kind of perfectionist constitutionalism and approached the document with a new conception about how to read it. They start out by differentiating the Constitution from existing interpretations of the Constitution and profess fidelity to the Constitution, the document, not official accounts of the Constitution, thereby liberating themselves from claims about the founders' intentions of the sort that's visible in the Madison Papers, claims about the founders' meaning, the Constitution's meaning of the kind enunciated by the Supreme Court in the Dred Scott case, and basically take an approach to interpreting the document that is familiar to us, has very high degree of natural law component to it, something that in the human rights context Jerry Newman calls a suprapositive element to the way in which they interpret the Constitution. I'm going to just read you from Frederick Douglass, his Glasgow speech of 1860, which is in our casebook. He says that the language of the law must be construed strictly in favor of justice and liberty. Where a law is susceptible of two meanings, the one making it accomplish an innocent purpose and the other making it accomplish a wicked purpose, we must in all cases adopt that which makes it accomplish an innocent purpose. This is the interpretive presumption with which he's construing the Constitution's text and insisting that it's not a pro-slavery document. So he reads the preamble, notwithstanding what the court had declared in Dred Scott, observing that we the people, not we the white people, not even we the citizens, not we the privileged class, not we the high, not we the low, but we the people, not we the horses, sheep, swine, and wheelbarrows, but we the people, we the human inhabitants. And if Negroes are people, they're included in the benefits of the Constitution of America, for which the Constitution of America was ordained and established. And so you get this revisionary reading. So this interpretive posture, which Sandy Levinson would call Protestant and Robert Cover would call utopian constitutionalism, is a key innovation in constitutional culture that Spooner, Douglass, and other of the abolitionists are contributing to the ways in which we know and read the document. And it helps engender the understandings of the Founders' Constitution, which find their fruition in the text of the Reconstruction Amendments. This understanding of how to read a Constitution was immediately turned against the Reconstruction Amendments by the women's movement. Having attempted to get a right to vote included in the Reconstruction Amendments, and having it bumped out by Section 2, the relatively rule-like suffrage language to which Jack was just referring, Stanton and Anthony thought they had to get an amendment. They thought they needed a 16th Amendment to the Constitution, but there was a spontaneous act of voting led by the minors, and in a new departure, claims were made under the 14th Amendment and its Privilege and Immunities Clause. The claim was that it enfranchised women. It's probably in light of these claims that the court actually construed the 14th Amendment's Privileges and Immunities Clause as it does in Slaughterhouse and then does again also in Minor against Habersat. There's a wonderful hearing in 1872 where the women's movement is seeking a Section 5 statute declaring that women have a right to vote under the 14th Amendment. And most of the claims for suffrage are made as claims on the original, the Founders' Constitution. Stanton, at that hearing, says the rule of interpretation, she cites Sumner, under the national Constitution is that, quote, anything for human rights is constitutional. And then she goes on and says, it's not safe to leave the, quote, intentions of the Pilgrim Fathers or the Heavenly Father wholly to masculine interpretation. For the Bible and the Constitution alike, women have thus far been declared the subjects, the slaves of men. So basically, she's turning this practice that she's learned in abolitionist movement in the Republican Party against the very new constitutional text that they created. I'm going to just read you one more quote. Martin Luther King in 1962, quoting Douglas, saying, its language is we the people, not we the white people, not even we the citizens, not we the privileged class, not we the high, the low, but we the people. So he's invoking Douglas in the same kind of a move. Of course, this is right in the wake of the sit-ins. You might think of Gavin Newsom and the marriages in San Francisco yet more recently. So I'm going to conclude with this statement of concern, which is that since Lysander Spooner and Frederick Douglass showed how to answer Garrison and Wendell Phillips, American constitutional argument has had a significant what I'm calling Jerry Newman has called a superpositive dimension, and deeply democratic role morality. Citizens inviting citizens, teaching them how to invoke the text against government in the court, which they regularly do. The American conservative movement invoked these understandings of role and practices of argument when it invoked the original understanding against Brown and against Roe, or on behalf of Second Amendment rights that eventually culminate in Heller. But the narrative of originalism is perpetually verging on the filio-pietistic, reverence for the Father, emphasizing moments of constitutional lawmaking in ways that can, although need not, eclipse the interpretive authority of ordinary citizens and the kinds of role morality that support utopian constitutionalism of the kind that gave birth to the Reconstruction Amendments. So I want to conclude by observing that Brown and Frontiero and Roe and Lawrence can be made consistent with some versions of originalism, but I at least wanted to take a position on this panel by stating the concern that the values that originalism venerates might treat these moments of constitutional change as problems rather than paradigm moments of constitutional change. If we're to venerate Reconstruction as a second founding, it has to be with attention, I'm going to argue, to questions of constitutional culture, to the understandings of role, authority, and practices of argument that gave birth to the Reconstruction Amendments. And in the end, the point is not merely in retrospect to justify Brown, but to ask ourselves about the forms of constitutional culture that will give rise to a Brown for the new millennium.
Thanks very much. Now I'd like to open this up to general questions, including comments or questions that the panelists might have for each other. Oh, good. We've got a microphone. I guess we can pass around. So here.
I had some questions about divorce. First, it seems to me the evidence is really equally coerced. You've got to ratify the amendment, getting rid of this isn't working. With reference to the 13th Amendment, it's equally coercive. And then the odd thing that happens with the southern states is they're not willing to be coerced. They reject the 14th Amendment. And it's only after that rejection that Congress decides that, well, we need a new electorate in the South. we need to enfranchise the blacks and so on. And so from one point of view, you can say, well, this is completely illegitimate because a new electorate... I'm sorry, is that better? So it has to be closer. Okay. With reference to the 14th Amendment, I was saying initially the southern states reject it. Everyone except for Tennessee rejects it. And then Congress decides, well, we just need a totally new political system in the South. And particularly we need a new electorate, and we need all of these black voters so that we can get a legislature that will approve the 14th Amendment. And they do say you got to do it before you get in. So from one point of view, you can say, well, gee, this is just terribly illegitimate because this isn't going through the conventional way. From another perspective, you can say, well, this is much truer to the democratic process. We now have, all these people who get to vote and didn't get to vote before. But maybe the southern states, if they had not been had their electorate completely changed, would have changed their approach and ratified. But the fact is they rejected it all.
I mean, if that was put to me, I guess I wasn't particularly interested in the legitimacy argument. I'm interested in how we read intentions and meanings in light of the way in which it was interpreted. And I guess I don't quite get the point here because, and it's of course true that the southern states initially rejected, and then they were kicked out and they were coerced back in. The reason why they eventually accepted the 14th Amendment is not because they had enfranchised their former slaves at that point. It was because they had to do that in order to get back in the Union. Now, it is true both that black enfranchisement was required as a condition of each of the individual acts, which, as you know, as each of the states was readmitted, that required legislation from Congress, and black enfranchisement was made a condition, and then ultimately the 15th Amendment came along. But that does not, black enfranchisement doesn't precede the 14th Amendment. It comes thereafter.
I wanted to say something related to this, because Michael's only talking about the question of what evidence is available when you interpret. And his point is you don't have very much evidence at the state level. All the evidence is Congress, and that limits the kind of things you're doing. I want to make a slightly different point related to what you're saying. There are two stories about Reconstruction, and there's a third one I want to offer. One story about Reconstruction is it was a disaster, it was a terrible thing, and thank God we restored the Union, and thank God we limited the scope of these crazy amendments and crazy statutes that were passed. That was the reigning view for many, many years, and the history of the Dunning School. Another narrative is one that basically tries to forget the trauma and says, isn't it great? In 1868, they put the equality in the Constitution, and it's been there ever since. And isn't it a good thing? And don't you see now we have a Constitution that's equal and treats everyone equal and guarantees equal citizenship? And that's a narrative that is a narrative of amnesia, but it's also one that was very convenient in the second Reconstruction in the 1960s. And there's a third narrative, which is more uncomfortable, but it's this. Essentially, we had a civil war, 500,000 people died. We had a completely unwilling part of the country that did not want to come back in, that was forced to through military force and power. And the victors in that victory, who had a whole bunch of political views, essentially pushed their views about the meaning of citizenship and about what the country was about on the defeated people and forced them to adopt it. And they did so using the 14th Amendment as the basic armistice. That is, this story is a story like about Iraq, or it's the Treaty of Versailles, and in which you may be rooting for a different group of people, but essentially this is a forcible imposition of a political order on an unwilling group of people, some of whom, by the way, in the conquered territory are happy about it, and most of whom are unhappy about it. And the question you have to ask yourself when you think about constitutional interpretation is, what are we to make of this story, which involves rupture, which involves violence, which involves imposition of a particular set of views about justice and rights and citizenship? There is no easy answer to that question, but it's in fact the narrative which we have to confront if we're going to think about how we marry originalism with constitutional interpretation.
Including also, I guess, the sort of difficulties in the positive lawmaking story of the Reconstruction amendments. I mean, just given the kind of work that Bruce Ackerman has done, sort of illuminating all of the ways in which there's sort of deficits for the rule of recognition, you basically are left looking at a much more sort of political foundation of the kind of authority that can be asserted through them. You know, other flat-like people.
Okay. Question over here?
Yeah, Alex Susses. Thanks so much. So much to think about, you know, and let me just add something to what Barry was saying about the difficulty of using the state conventions. And the 13th Amendment ratification convention, there is far less, where we have the joint committee with the 14th Amendment. With the 13th Amendment, many states, many northern states ratify within a week. Illinois, if I recall correctly, ratifies within 24 hours. There is no record. Or if it is, it's minimalistic. In fact, most of the record is the southern state record arguing against the use of Section 2 as a strengthening of the congressional powers. And whereas the civil rights cases come 17 years after that, we've got the Civil Rights Act of 1875, which Michael McConnell has discussed, and of course the debates from 1870 to give us some passage of these meanings, but yet some evolving definitions of what is meant. And if you look at those debates, and I know Michael has looked at them much more deeply than I have, they're not talking about 13th Amendment or 14th Amendment. They're not even very specific about what they're talking about in the way that Harlan was in his dissent to the civil rights cases or to Plessy. And so the original meanings seem to be absolutely critical for understanding the American creed that evolves from the Declaration, but yet they're only just a takeoff point, as the miners proved, and as Susan B. Anthony proved in that criminal case, because if you look at the Equal Protection Convention of 1866, when Wendell Phillips stands up and he says, this is the Negro hour, they are not talking about women's rights, yet I think Riva is right, that they adopted these radical constitutional abolitionist methods of interpretation, but they are not absent of originalism, but yet they interpret them to be more true to the fundamental meaning of equal protection, due process, but unfortunately privileges and immunities remains virtually closed at this point.
Well, may I just throw one thing in about Frederick Douglass? In the Glasgow speech, what he says is the Constitution be interpreted strictly in order to produce the results that he wanted. He didn't say it should be interpreted loosely. In fact, and that's not. I'm not just playing on the one word. He then gives an amazingly crabbed interpretation to the words. He gives a very he doesn't go into flights of fancy about the words. What he does is he says, let's look at these words very narrowly, very strictly, and at each of the points at which slavery was mentioned in the original Constitution, they always adopted a euphemism. And that was deliberate too. I mean, at one point, Gouverneur Morris tries to force them to use real words, and nobody wanted to do it. And then Frederick Douglass brilliantly takes advantage of the euphemisms to show, well, then they must. We should not read into it their intent to cover slavery. We should look at their words and not give them any more than that. And so I just did want to mention that because I think this idea that Frederick Douglass's style of interpretation ought to inspire a kind of fanciful looseness is not true to his method.
Can I actually read the exact language? He says, the language of the law must be construed strictly in favor of justice and liberty, where the law is susceptible of two meanings, the one making it accomplish an innocent purpose and the other making it accomplish a wicked purpose. We must in all cases adopt that which makes it accomplish an innocent purpose. Now, he's using strict in a very special way there. he's saying he's going to construe it narrowly so as not to recognize possible institutionalization of slavery of the kind that the framers contemplated, but it's not strict in the sense he's incorporating it into it openly, a normative view that he wants to make it morally appealing or attractive rather than not. That's what he means by strict here. And I don't know that loose actually gets at it. I probably would call it dynamic, but I am trying to put on the table the question of whether this method of interpretation, which helps generate the understandings that produce the Reconstruction amendments as themselves interpretations of the founders' document, whether that method of interpretation is what, well, this panel may have different views about whatever originalism is, but I'm not sure that what this is originalist. And so, having been invited to think about the second founding and originalism, I'm putting on the table the interpretive commitments of the group of abolitionists who helped bring into being the understandings enshrined in the Reconstruction amendments. So I don't think they're loose, but I don't think they're, let's talk about whether they're originalist.
Can I give you a word? It's because I don't know if I'd use dynamic. I think I'd use purposive. I mean, I think that's the type of interpretation that's being suggested, which is that you sort of figure out what the underlying purpose is, and that's consistent with Jack's view of things.
On the contrary, I mean, if we're talking about exactly the opposite for Frederick Douglass. He's a textualist, and he's saying don't interpret these words in accordance with what we know was their intention. Their intention was to protect slavery. He says don't give them that. Stop with the strict meaning of the words themselves, and don't move in them. Don't do the purpose of
Here, the passage
now,
continues.
I don't necessarily say, I'm not arguing that means therefore, that's the way we ought to move, but just as long as Frederick Douglass is on the table, I think we ought to try to get him right.
Just one more sentence. The Constitution, now he's talking about the Founders' Constitution, because this is the document that he's saying is not pro-slavery, and that's the point of the Glasgow speech. The Constitution declares that no person shall be deprived of life, liberty, or property without due process of law. It secures to every man the right of trial by jury, the privilege of the writ of habeas corpus, the great writ that put an end to slavery and slave hunting in England, and it secures to every state a republican form of government. Here he continues, any one of these provisions in the hands of abolitionist statesmen and backed up by a right moral sentiment would put an end to slavery in America. Okay, that's what, this is all from this same speech. So what is...
the same thing about Bill of Attainder.
Right, Bill of Attainder, the preamble, the guarantee clause, the privileges and immunities clause, Michael's nodding. These are the clauses of the Founders' Constitution that the abolitionists invoked on behalf of freedom. And they're the clauses which the women's movement then invokes against the abolitionists, against the Reconstruction amendments on behalf of the vote subsequently. So that's just simply to say, I'm trying to put on the table, is this method of interpreting originalist?
So just a word on this, and then to the broad. This method of interpretation is clearly not originalist, except perhaps on Jack's version,
right.
Originalism, right? That is, and Douglass's method of interpretation could, per Berry, be called purposivist, but only if purposivist doesn't mean anything about the purposes of the drafters or the ratifiers, but means rather, per the passages that we've read, here I have an ambiguous text. I will read it for the purpose of making it more just or more innocent. So what clearly what he's not saying is strict in the sense of read the language and let the chips fall where they may. That's clearly not, what he's saying. But, and then to bring back Sandy Levinson, right, Protestantism always has a morality, right? And so you read the text in a Protestant way, and Jack has written about how you could think of that as an originalist way, but for a purpose in that sense. Larger thought, maybe. One of the themes here is erasure, historically and otherwise. I, in various introductory comments, was having a little trouble knowing, I'm sorry, I'm Richard Primus from the University of Michigan. I was having a little trouble knowing how to think about the repeated statement that this is a new thing to talk about originalism and Reconstruction. It would come as news to many people that it was a new thing, right? It would, and not just to Bruce Ackerman and Akhil Amar. It would come as news to Alex Bickle and to Charles Fairman. And I mean, the shelves are filled with people who have been, Jacobus Tenbrook, right? For a long time, people have been writing about the original intentions, meanings, understandings of the Reconstruction amendments. And everyone on the panel knows this. So what does it mean to say nobody has really done this before, right? What is the this that we think is in some way new? And one possibility is that it's an attempt to change the scope, right, the throw weight of that question relative to the throw weight of the question, what do original meanings from the 1780s mean, right? Where if there is a paradigm that says the big headline, the big framework is the 1780s, and then there's other important originalism to be done, but it's secondary from the 1860s and 70s, the attempt is like one of those maps that changes Mercator projection to real area projection, or that changes electoral vote to popular vote, to say, no, the thing you thought of as the big thing is the small thing, and the thing you thought of as the small thing is the bigger thing, and we are all more children of Reconstruction than we are of the first founding. And if you really wanted to push that, we wouldn't call this the second founding, we'd call it the third founding. Right? You'd say there was a founding with the Articles of Confederation, Revolution, Government, Constitution. Then there was a second founding in 1787. Then there was a third founding in the 1860s. This would further destabilize the idea that what you thought was the big thing was the big thing. Right? And the purpose of doing this, it seems to me, is to reframe the big narrative, right? And to say, if, again, on Jack's version, I have many skepticisms about Jack's form of originalism, but going with it for a moment, if the purpose is to change the big narrative so that we change what seems to make sense of us as the story we want to tell, right, or per Barry, like what synthetic story we want to tell about constitutional history generally, if you change what you think is the big thing, you'll change the story, and you'll change what textual meanings seem plausible, and you'll change what constitutional outcomes seem appropriate. It's a rhetorical reframing. I don't mean that necessarily in a pejorative sense. But then I have this question. One of the difficulties with that reframing is that it puts a lot of Americans in their own minds on the side of the bad guys. Right? One convenient thing about taking the 1780s as the big thing, or as taking the confrontation with European totalitarianism or the Great Depression and the Four Horsemen as the paradigms, is that nobody really thinks of themselves as being on the side of the bad guys. But many Americans identify with the heritage of the white South. Millions and millions and millions of them. And if that becomes the framing, and if you reconfront the gorier, messier narrative of Reconstruction, it becomes necessary for those people either to change their identities in painful ways or to be on the other side, right? One of the things that downplaying Reconstruction has always done, right, is permit us to avoid that problem. So I wonder what thoughts you have about that piece.
I want to say Sandy and I wrote this piece many years ago, and we pointed out that every year college seniors have a football game called the Blue-Gray game, and in Europe they have nothing called the Resistance Nazi Bowl. And that's your story. I mean, the point is, in order to reform the Union, you had to reform the Union about a new narrative in which all of us are Americans, and it's just a very difficult narrative to construct unless everybody can, say, oh yes, I'm an American too, and that makes it very difficult to articulate the meaning of Reconstruction. That, by the way, that's not a statement about interpretation yet. That's a story about how do we reconstruct today the meaning of America.
Yeah, I think it's a great point. It's an excellent point. And the only thing I would say in response is, I sort of have a two-way view of this project, which is one is, yes, when you emphasize parts of the story, you change the story, and that's really important. And it's interesting to see the ways in which the story will change. I think it will change, and I think that is what's motivating part of this. But the other part is the insidiousness of this to the endeavor of originalism, and I don't mean to be shy about that, which is I just think this complicates originalism in ways that makes. And when I say complicates originalism, I mean I thought Michael's comments were terrific, and I have huge sympathy for them. And I'm a lawyer, just like everybody else in the room, or the ones who are lawyers. And we all start with the text, and we move to intent. I mean, that's just kind of how you interpret it. And I think that originalism has a sound core that you can't get away from. It's what you do next, and what you do with everything that happens next. And I think everything important about Reconstruction starts there, and then moves forward in these really complicated ways. And I don't know what to do with your question except to say that, at some level you start to bring people into the story gradually over time. And I think that's what's happened in this country and is still happening.
Hi, Richard Ains from Akron. I want to make a comment and then maybe ask a question. Comment very briefly, but it reverts back to what Michael King Curtis suggested. And I think that one of the things we have to think about is who is the South? And I know that sounds simplistic, but so many times, I probably make this mistake too, but I'm reading and people are talking about the South. Well, they're talking about the white slaveholding elite. They're not talking about African Americans who are born in the South where they're free or slave. They're not talking about unionists. I think we have documentation that somewhere over 200,000 African Americans fought for the Union in the Civil War, most of those from the South. We can also document something like 120,000 white Unionists who fought in the Civil War. I'm thinking about the secessionist movement in Arkansas. The future Reconstruction governor refuses to change his vote to make it unanimous. And he says, we will meet you at the foothills with our muskets in our hands. So I think when we think about the point of what does the Southern ratification or non-ratification tell us, we've got to look beyond that white elite that Johnson put in place because he displaced the broader group that Lincoln had in place. And then, of course, Reconstruction comes in later. And I guess the question I wonder is, and I think Judge McConnell prompted this. I don't know if this is really fairly your question or not, but, if you look at the amendment in the ways that I think Jack pointed out, it's not a single amendment. It is more like the first Constitution than the first set of amendments. On the first set of amendments, you got to vote yes or no and pick and choose. On the first Constitution, you had to take the good with the bad. 14th Amendment has all of these provisions in it, and you have to take the good with the bad. And I think that's one of the things that explains why there could be discontent and resistance among people even who voted in favor of the amendment after it's passed because they don't like certain provisions of it. But they made a decision that it's more important to win out on, say, apportionment of the Congress than it was to have the citizenship clause the way they wanted it. And I guess I'm just wondering if you don't think that type of ratification not only shifts some importance away from the ratifiers to the framers because of this all or nothing, and second, if it doesn't explain some of these inconsistencies that people like Charles Fairman like to pick up and argue about.
Steve Calabresi at Northwestern. I have a question for Judge McConnell, and my question is really over how originalist we should be in enforcing individual rights. In particular, most of the cases that the Supreme Court decides that bear on individual rights are generally 14th Amendment cases. They're not technically Bill of Rights cases. And so if one is dealing with a 14th Amendment case involving, for example, the freedom of speech, maybe one might want to ask, what did the freedom of speech mean in 1868, not what did it mean in 1791? Was it only about prior restraints? Similarly, if you're asking about whether the Takings Clause has any bearing on regulatory takings, you would not look as Bill Traynor did at 1791. You'd ask, what did the Takings Clause mean in 1868? Same thing with free exercise or cruel and unusual punishment. If one takes that approach, then I think Barry Friedman might be wrong, and that in fact looking at 1868 might make originalism more viable rather than less viable. I just wondered if you had any thoughts.
I think it's a great question. I don't know the answer to this. I mean, one of the clauses for which it's particularly salient is the Establishment Clause. Kurt Lash has done the best treatment of this because the original Establishment Clause essentially guaranteed to the states the right not just to not have to have an establishment as well as not to have one, and there's pretty good, I mean, I don't think it's overwhelming, but pretty good evidence that by the time of the 14th Amendment, certainly the formal establishments had all been dismantled, and there's some good reason to believe that even the language, a law respecting the establishment of religion, had come to mean something different from what it had meant back then. So I think it's an interesting and provocative argument. I'm not sure that and it might even be the best way to read. That would be I would want to do a lot more work and thinking before I fully embraced it. The Second Amendment, I mean, it certainly seems to me that the history of the Second Amendment being an individual right of self-defense is way stronger by the time of 1866 than it was at the beginning, and had become, you know, I mean, that was one of the rights that the white Southerners were most frightened that the freedmen would be able to exercise, and was of an enormous practical importance. I mean, so it's going to cut in different ways. I'm not 100% sure where I would ultimately come down, but I think it's because there is another way to look at it. I mean, you can say that what they were doing, they were so formalistic in a way, at least at the debates at the congressional level. They didn't talk about what any of these rights meant. I mean, I can think, you know, I think of Congressman Shellabarger saying, and what are these privileges and immunities to which we refer? And then he just reads the first 8 amendments of the Constitution, right? And it's as if rather than reconceptualizing them, all they're really doing is just saying, yeah, and whatever that was, now the states have to comply as well. So I just don't know which way to go with it.
I think that there's, I mean, that method of thinking about what the meaning of the either incorporated rights or privileges and immunities might be really starts to get much more common law-like, and you lose any sort of localized sense of any record of positive lawmaking, given the sort of abstract commitments that are expressed, you know. And so the question of how you would operationalize this, that is to say actually use it to decide what's in and out, is kind of obscure. A second question that I just thought I would throw out on the table, Richard before just raised a question about ways in which getting historically particularized about the history of Reconstruction can center divisive racial and regional disputes, puts to mind another set of issues, which is who was enfranchised to have a voice in the scope of the Reconstruction Amendments, and whatever's to be said about that at the time of the founding. What's striking about the second founding is that there's sort of a sense of normative ambivalence about the status exclusions that define the electorate, and to the extent that the Reconstruction Amendments themselves begin to summon a world beyond themselves of more wide-ranging social participation, focusing on what the lawmakers said, you know, those enfranchised to, you know, in the position to draft or in the role position to vote on them, is really looking at just a very narrow swath of what the amendments deem to be the relevant community. There's a transitional justice problem here, in other words. It's a fairly powerful one, at least in the case of race, whatever's to be said about the gender case, right, or any other, which the more formalistic methodologically we are about the way we would consider the nature, I mean, using originalism as a method to get at the meaning of the amendments, the more we encounter that set of questions. So it's just another one on the table.
Randy, just one more question. I think we're running low on time.
Okay, mine's more of a comment. This is Randy Barnett from Georgetown. It's more of a comment than a question. I think if you move from original understanding to original public meaning, you dissolve some of the apparent paradoxes of what the enterprise is about. Original understanding does invite this idea that you have to look at what everybody subjectively thought in the ratification conventions, and the evidence is weak, and then you have the problem of coercion of some people. It all seems to very, very complicated. And difficult. If you look at the original public meaning as the original semantic meaning of the language in context at the time it was used, then evidence of usage, which we're accustomed to doing in all sorts of enterprises, becomes relevant, and this evidence can exist before, it could exist during, it could even exist after in the form of how Congress uses the language that was implemented. Evidence of public of usage is the evidence you appeal to figure out what public meaning was. And the idea that you could be coerced to sign on to something that had a semantic meaning is not paradoxical at all. We can all imagine somebody putting a gun to someone's head and said, sign this contract, and that signs your land over to me. Now, the gun to the head is responsible for how the thing got signed, but the fact that what the document says is the land now is mine is a matter of the semantic meaning of the text that the person signed. What the gun to the head does is undermine the legitimacy of enforcing that document, but it doesn't change the semantic meaning of the document. Now, the last thing I'll just say is when you plug public meaning into the issue that was separating Spooner and Douglas from the Garrisonians, what you had, because of the introduction of euphemism into the Constitution, you have the deliberate choice by people who wrote this text of using words that meant other than what they meant. So they used words that had an innocent public meaning, and they did not use the obvious word that had the incriminating or inculpating public meaning. And there's two ways you can describe that situation. One, you could say, which is what Spooner and Douglas argued, that we're only bound by the public meaning and we're not bound by this insidious meaning that's only revealed when you do historical research to find out what the true intentions were. That's one way to describe it. The other way to describe it is that by choosing euphemistic language, the founders injected a deliberate ambiguity into the text. It could either mean the insidious meaning or it could mean the beneficent meaning. That's another way of describing it. But if that's true, and if the Constitution's original meaning is deliberately ambiguous, then it requires constitutional construction to decide which of those meanings you pick. And Douglas and Spooner proposed a rule of construction, which is you pick the innocent one. You pick the one that doesn't do manifest injustice rather than the unjust one, as a normative matter, not as a matter of meaning or interpretation, but as a normative matter.
Kim's graciously allowed me just to say one thing about, I thought Steve's question was terrific, and I just want to use it to make what I think is a really important point about this. So I take Stephen's question to be, okay, but when we ratify the 14th Amendment, we arguably incorporate the prior terms of the Bill of Rights, and so maybe that's the moment that we should look at, and that's the second thing I talked about, which is integration. But the question I'd ask back is, if you're thinking about incorporation, is it really plausible to believe that those amendments could have been incorporated and applied against the states at that moment, or was it not until much later in history when the actual incorporation happened in the court's terms and the country was ready to sort of buy that incorporation against the states? It became plausible and sustainable to apply those amendments against the states in that way. If you think it wasn't plausible, sustainable at the time of the Privileges or Immunities Clause, and it only happens later, then I have to ask the question of, okay, don't we need to look then at what happens later and why it became plausible and sustainable then and what to make of that period?
Well, this has been a great discussion. I know it could go on much longer, but I'm sure we'll have the opportunity to revisit some of these questions on the panels that are to come. So please join me in thanking our panelists.